Welcome to another episode of Let's Talk Death Care with me, Tabisile. And today I am joined by a very special guest who will be talking about everything deceased estate. I'm sure we've all lost a loved one and we know the pain of reporting an estate, especially when you don't know what to do and what forms to fill in. So, Bless, welcome. Please introduce yourself and tell us a little bit more about what you do.
Hi, Tabisile. Thank you for having me, and let me greet the viewers at home. My name is Bless Mashele, and I'm practicing under the name and style Bless Mashele Attorneys. Thank you. I'm an attorney.
Of course.
In short, we would normally say I am a legal practitioner, as times have changed, and how we normally refer to ourselves would say we are legal practitioners.
Right.
Yes,
All
put it that
right.
way. So we are legal practitioners, not just attorneys or advocates. So the term that we now use is legal practitioners.
All
So
right,
to put it that
fantastic.
way.
Now, I invited you today to tell us more about deceased estate. What is deceased estate, and how does one report deceased estate?
Okay. Firstly, people need to understand that deceased estate comes into existence when a person dies. So when we speak about deceased estates, that's when we are talking about the assets of the deceased, liabilities, as well as the debts, because most people tend to forget about the debts and only consider the assets only. So deceased estate involves the assets of the deceased, liabilities, and the debts. And then, how do we now report the estate of the deceased person? That now depends on, did the person die intestate or testate? Meaning that, did the person die leaving a will behind, or they didn't leave any will behind? So we look at that before we can report the estate. So after determining that part on whether the person died intestate or testate, we now look at the beneficiaries or the surviving spouse. And then how do we now then report the estate? You go to the nearest magistrate office or the master of the high court. So normally the issue of jurisdiction comes in place. Okay. So if, for an example, you were staying in let's say Orange Farm,
Yeah.
you'd go to the court in Orange Farm.
Okay.
You wouldn't go to Polokwane to report an estate in Polokwane. I'm sure you are following so far.
Okay, so just around that, are you saying that, for example, if my parents passed on whilst staying in Limpopo and I stay in Joburg, I need to report that estate in Limpopo,
Yes.
not kickstart the process in Joburg?
Yes.
All right. And then the second question I have for you is, you spoke about assets. So normally, what would be assets that our families have? What are those? What are those assets? Is it a house or is it a car? How do we classify assets?
Okay, by assets, we are actually referring to everything that the deceased owned. For example, we are talking about the immovable property, the movable property, the claims in favor of the estate. For an example, if you owed me 100,000, that money forms or becomes a claim in favor of the estate. It has to be paid in the estate account. So
Okay.
those things or those amounts, they also form part of the estate. Okay. So we calculate all those assets, the immovable, movable, even the debts, because the debts form part of the liabilities of the estate, and they need to be accounted for.
Sure. Okay. So then now you're speaking about debts. Just before I get to debts, I want to understand, we spoke about how you report the estate. Who must report the estate? I think that's the most important part. And the reason I'm asking this is because you find that in so many families where there's siblings and there's, the spouse left, there seems to be a big fight about who has the letter of authority, who has the letter of executorship. So in answering my question, please start with who has the right and what's the difference between a letter of executorship and a letter of authority?
Okay, let me start with the difference between a letter of authority and a letter of executorship. So a letter of authority It's issued when the total assets or the gross value of the assets are not more than 250,000. And in that particular estate, master's representative is appointed in that estate. Note that part. And then when a letter of executorship is issued, in that particular estate, an executor is appointed always. So the difference between the two, it's the values of the total assets. If the total assets of the deceased are more than 250,000, in that particular instance, a letter of executorship will be issued. So a number of people mostly they make that mistake of saying or applying or going to court and say, no, I need a letter of authority, instead of saying I need a letter of executorship. So determining that part, we calculate the total assets of the deceased. For an example, if the deceased had a car and a house, and those two, they are totaling 200,000, a letter of authority will be issued in that particular instance. And then if maybe, for an example, the deceased had a house and all the other things, and then the total or the gross value thereof, it's 500,000. In that particular instance, a letter of executorship will be issued. So make no mistake of finding yourself with a letter of authority instead of a letter of executorship, because it will give you problems when you now need to administer or wind up the estate. Maybe you want to sell the house and that house is worth 300,000 and you have a letter of authority. You won't be able to transfer that house from the deceased to the beneficiaries or the heirs.
Sure.
So it's important for us to understand, especially the difference between the two, a letter of authority and a letter of executorship. So whenever you report the estate, how we normally classify who's supposed to report the estate. For an example, if the deceased was married, obviously the surviving spouse has to report the estate. If there's no surviving spouse, the children of the deceased person has to report the estate. In an instance where, maybe for an example, the person died intestate, that is without a will. That's when we apply the laws or the rules in terms of the Interstate Succession Act. So we are mostly guided by that. If maybe there's a spouse, we are going to do it according to the Interstate Succession Act. If there are no, let's say for example, there are no children and there's no spouse, that's when we look at the parents of the deceased and the siblings. So you don't just come as a sibling and you skip the wife and the children and you report the estate. It doesn't work that way.
So you're saying that in bold letters.
Yes. They need to understand this, because if the person died intestate, we need to look at whether the person had a wife or whether the person had children or the other family members, the closest family members. We are talking about the parents of the deceased, the siblings of the deceased, before we can get to the aunties and uncles. So we normally look at it that way. So if the person died with a will, obviously he or she would have appointed an executor.
Yes.
To administer the estate or to wind up the estate. And another thing that people should know, you have a right to appoint whichever that you want or like to administer or to be the executor of your estate. For an example, if you come to our firm, for an example, we have to explain to you all the rights in terms of appointing an executor. So we don't need to give you the pressure of saying, no, appoint me, appoint Bless as the executor. No, I need to explain to you all the processes and the duties of the executor, especially when it comes to paying the administration expenses at all costs, because that's where confusion is. Most entities, they will appoint themselves as executors without explaining to the testator, what does the executor do? What do you have to do? What are your tasks and what are your duties thereof when you administer the estate? So you need to know that you have a right to appoint any person as the executor, meaning that I can appoint Tabisile to be my executor. Like she doesn't have to be my friend, or she doesn't have to be my sister in order for her to qualify to be an executor. But you need to know that there are rules applicable thereof. For an example, if you appointed someone who's not your relative, there's what we call bond of security that person has to pay when administering that estate. So it's a different topic that people need to understand, that when you administer an estate, the executor needs to understand the duties. So, as a legal practitioner, usually when explaining those issues to the testator, I'll let them know that there are administration expenses that you need to cover.
Yeah.
You need to know about those ones. That's when we speak about the 3.5% that normally people fight about.
Yeah.
So it's there, it's fixed, it's in terms of the Estate Act. So it's not something that comes or something that we just formulate and decide on, okay, for this estate, I'm going to bill 10%.
10%.
No. It's fixed. It's
Yeah.
3.5%.
Yeah.
So I think in that particular line, I've answered the question of the difference between a letter of authority and a letter of executorship. So make no mistake of finding yourself with a letter of authority instead of a letter of executorship. It's a problem.
I like what you said. And with the different institutions that you have mentioned, who we will not mention by name, that decide to appoint themselves as executors, what do you then do when they frustrate the process, when they're not moving with the process? Because we know of so many stories where the wheels are just sitting there, the family is frustrated, nothing is moving. Do I then have a right to remove that executor and then appoint my executor without incurring any other fees that was due to that institution?
It becomes a bit tricky. It's a bit tricky for the beneficiaries to remove the executor, because remember, the executor there was appointed by the testator. So somehow we need to respect the wishes of the testator. So one way or another, if me, for example, you happen to be in a situation where that institution or that entity doesn't report the estate or doesn't wind up the estate, what you can do, you can actually report the matter to the master, and then they will give you directions. And at some point, you might even require or request them to renounce as the executor. And in most instances, they don't even agree. They're like, no, we are appointed by the testator, so therefore, you wait for us.
And I'm glad you're mentioning these things, because those cases are there. And it's quite frustrating when people come to you and say, this matter has been sitting for 3 years, for 4 years. And you understand that as that matter is not being rounded up, the estate is still incurring costs. The kids are still not being able to go to school because there are monies that are needed to take them to school. But one thing that you've spoken about, in terms of the executor as well. So what I am also wanting to know is there some sort of training that you need to take your family through, or you need to bring them when you do your estate planning? Because a lot of people, like you said, are surprised and shocked when they realize that there is actually a cost to dying, that they need to pay these estate duties. And I always think that it's better when they know beforehand that in actual fact, when you draft, they will know that in executing this will, there are monies that need to be paid. And that is why I'm very much against, and yes, I'll say this on this platform, I'm very much against DIY online wills, because those things are not disclosed. People don't know that there's a cost to that. They think, it's a free will. At the time where, I've passed on, they will execute on my wishes and my family will get my money, not considering that there's actually cost attached to administering that estate.
True. I just don't know how do they do this free wills and whatnot, or when they go to those entities, whether they do explain to them all these details. Because when you do a will, when you execute a will, the main thing that you should know, you should understand the things that you are writing in your will, and you should understand also the expenses that your estate is going to incur.
Yeah.
Because the house won't just move from Bless to my child just like that. There has to be we need to account to SARS. There's what we call transfer duty. It has to be paid somewhere, somehow. So people need to understand that in as much as you write a will, you need to include in your will that the administration expenses need to be paid. In fact, it's even wise to include that in your will, to say, okay, I'm reserving this much to cover administration expenses. You are saving your beneficiaries the expense of having to pay the other costs for administration expenses. For an example, if you come and we are doing a will with you, we are going to make it a point that we discuss, or maybe write down all your assets and calculate the executor's fee. There's the executor's remuneration, the 3.5%.
Yeah.
Calculate it so that you know that your beneficiaries will be expected to pay this much. So how about you reserve some funds to cover that, in order for them not to have that burden to pay the administration expenses. So those expenses normally entail, or they include, the master's fees, advertisements fees, the executor's fees. If there are bond costs, they are included in there. If, for an example, under liabilities, we also include funeral expenses of the deceased. If you paid for the funeral of the deceased, you can now come at a later stage to say, oh, I paid for this, and then this is the expenses that we incurred. And when we do the L&D, the liquidation and distribution account, we account for those things. And when we now distribute, we pay that person the costs. So most people don't even know that at some point we do pay the funeral expenses to whoever that incurred the funeral expenses. Same applies when we talk about the master's fees. Those are the fees that need to be paid. Whether you like it or you don't like it, they have to be paid. They need to be calculated. And they are calculated according to the total assets of the deceased. So as the executor, you need to know that it's your duty to ensure that all the assets of the deceased, they are collected and they are all accounted for. So you don't disclose one car and you leave 5 cars at home. We'll find out one way or another.
Absolutely.
Whether there are other cars. Or you come back and now you want to transfer the house and you're asking, no, I have a letter of authority. I didn't know whether I had to include all the other assets. Then what do we do in that particular instance? We need to amend that letter of authority, and the process becomes longer. So it's your duty as the executor, or as the family members, or as the spouse, make sure that all the assets of the deceased, they are in one place, and they are all accounted for. Because at the end of the day, we need to also pay SARS. These your debts that you're busy dodging and ducking and diving, they need to be paid.
I'm glad you mentioned that.
We need to account to SARS.
Because people think when they pass on their debts,
no
debts fall away.
No ways. Your debts will be there. SARS will be there. SARS, if you keep running away from SARS, when you die,
I always say, if there's one person that can find you in South Africa, it's definitely SARS.
SARS
can find you.
You can never run away from SARS.
And in what you said, because I did a content speaking about the fact that some people leave debts, right? Mm-hmm. And some people leave credit cards, and they take credit cards and spend, those monies on useless things. At a later stage, they've passed on. Now their spouse, particularly if they're married in community of property, are liable for those debts, right? Definitely. And people spoke about credit insurance. And I'm saying to them, but you need to understand that when you're self-employed or when you're a contractor, it's optional. It's not a must. And over and above that, what you do find is that there's also SARS. How do you have credit insurance for SARS? Because SARS is not credit. And it will be calculated as it's supposed to be calculated. So you can't really, say I'm going to take up insurance for SARS unless, of course, you've got a life cover, or, you've got some liquidity that you've created to make sure that that SARS is paid off. So the reason why I'm speaking about this is, and I know maybe, this is not fair from a financial point of view, or maybe needs a financial planner, but you will guide. In terms of, trying to safeguard your children's inheritance because of all these other costs. How do you do that? How do you, sort of try and structure liquidity to make sure that it pays off against whatever costs that come in regards to the estate?
With that part, it's crucial to do estate planning, to plan your estate. For an example, you go and seek financial advice, and you go to a legal practitioner where you're going to sit down and discuss your assets, your liabilities, and whatnot, to try and balance those things, all those things. Because if you don't plan your estate, you are leaving your spouse with all your debts and all of these things. For an example, for parties that are married in community of property, a number of them would normally say that, no, the debts are not mine, they're his. No, the debts are yours. Because when that person dies, we are now administering a joint estate. So meaning that we are putting everything that belongs to both you and your spouse.
accounts are
We are putting
frozen.
everything in the table. If that person had a loan, 500,000, and then paid loan for someone else, asingeni ndawo lapho. What we do, we administer. I get it's a loan.
Yes.
And he took the loan, or he or she took the loan in his name. And we are now dealing with a joint estate. In that particular instance, as a spouse, you'll be left with debts to pay, debts to settle, because the estate has to be administered. And you said, saka ke sararo, sararo ke saka. So that includes the debts as well. It's not only the profit. In community of property, it's in community of property, profit and losses. The losses, we are talking about debts there. And a number of them make that mistake of not disclosing the debts. And the creditors come in. When we advertise the estate, the creditors come in with their skoloto. No, this person owes us this much. And then we put it there.
But that's
And
why
if there's sufficient fund there, we pay them.
But you see, that's why I say that, and I think this is a conversation we're having around educating people around in community of property. Because I really think that that's the most unsecure marriage regime you can literally enter
True.
into. Because you just never know. The only certain thing that guarantees you is the uncertainty. Because
Exactly.
you know sometimes, and like you're saying, when you advertise the estate, your partner did not even know they had kids outside of the marriage. Maybe they had, that and then the lady decided, I'm not gonna tell this person, I don't want them in my life, I'll just raise this kid by myself. But in the event that you pass on, they come back.
Exactly.
And I want to make another example, because men sort of think like I want them to die first, because most of the examples that I bring relates to men. I'm like, but have you seen the cases? Have you read the cases? Some ladies go and marry and they leave their kids with their aunties, and they come into this marriage and claim not to have kids. And in the event that they pass on, that kid comes and says, this is my mother.
This is my father. This is my mother.
So it's very important that people have these conversations. And I can promise you, the most stubborn people to educate about in community of property marriages are the ones who are in community of property. Next, and let that one spouse die. That's when they actually.
That's when they
willing
realize
to listen.
I messed up. When you are married in community of property, let's say when we administer those estates, there will be a number of kids coming in, and then the wife will be fighting. No, they're not supposed to get anything. And another thing that surviving spouses need to know. If you have kids, let's say for an example, I am married in community of property and I have 4 kids, and my husband has other kids, when we administer the estate, disclose all the children. Don't just write abako pants and say, no, we had 4 kids. Include also the other ones. If he had 3 kids elsewhere, ask for their documents, include them, so that they can get what belongs to them. The reason why I'm saying this, they are going to come and claim either way. They are going to go to the master and then lay a claim there. And then if I'm the legal practitioner administering the estate, obviously you'll hear from me. Oh, okay, there are so and so kids. There are 4 kids who came, or there are 3 kids who came. Yeah. They're saying this and this and this and this and this. And then we need to add them in the estate. If you're saying, okay, you are alleging or you need DNA test, then it's going to be done. And who bears the cost? The estate.
Sure.
So save yourself the embarrassment, because we normally see these things on TV. But what's the show? Gugitila and Mama Zala. We see those things. We
Yeah.
see those. It's always the issue of letter of authority, letter of executorship, or you didn't give the children or the beneficiaries what was due to them. And a number of people make a mistake when they have a letter of authority. No, they stop the process. They think automatically by
That's
receiving
where
the
I was
letter.
going to.
No, ogwami look,
That's where I was
ogwami.
going to.
That is the mistake that most people are making.
True.
They make those mistakes,
And I think
and some they do it intentionally.
because you know with what you've just said, Bless, I think the one thing I'm taking out of that is, imagine if I nominate my husband as an executor and he did not know that I had kids that I was hiding with my sisters and aunts, and he's going to frustrate the process, because
Exactly.
why are these kids supposed to get monies from the estate? Because it's also his, not understanding that my kids must inherit something from me. And this is what normally happens when a lot of men make their wives executors of their estates.
Exactly. In a number of instances, if as the surviving spouse you are the executor, put your differences aside. Those your issues, your anger issues, put them aside, and think for ingane. When there are 4 kids, and then okay, he has other 2 kids, call the parents and ask for the documents. If the parents are not cooperating, tell your legal practitioner that, you know what, my husband had other kids
Children.
outside. There are other kids out of wedlock. Let them know of that information. Give them that information. And then as a legal practitioner, I'll know how to deal with this thing. I'll know how to go about it. I'll know how to get or explain the situation to those mothers or whichever the baby mamas and whatsoever not. Because at some point, a number of them will like, no, I don't want to talk to that baby mama. And I'll be like, no, I leave that to me or leave that to us. We'll attend to it for you.
Exactly.
Because the whole point of not including them, you are more like trying to defraud the children, those children. You are more like trying to defraud the estate, because it's gonna stall.
Yeah.
Izomale estate, because we are not doing the things properly. If we are talking about administering the estate, we are talking about giving abantwana or whoever, or the parents or whoever is entitled to getting whatever that they're supposed to get according to the way they're supposed to get it. Not just giving it's okay, le eyakho, le izohamba nani, le izohlala, le isihlala nayo. It doesn't work that way.
And then the one part which is very interesting, which has been spoken about Gakulo on the internet, and this is where I want you to rubber stamp in terms of giving us clarity.
Okay, noted.
When a spouse in community of property passes on and does not include the other spouse in the will, what happens?
Okay, in that particular instance, if a spouse execute a will and that spouse is married in community of property, what usually happens in that particular instance, that other party is still entitled to 50% share of everything that is in that will. If you wrote in the will that, the house, I'm giving it to so and so, when we give that house, if the value of that house is 500,000, when we give that house to that person, we are going to divide that 500,000 by 2, and that is going to be 250. So we are going to give that person 250, and then that one gets 50% share. That belongs to them. So if maybe it's a number of items, it's a number of assets, we are going to do that for each and every asset. 50%. So a number of people think that when you do a will and you exclude your wife, automatically they're going to be excluded, or your husband.
Yeah.
No, it doesn't work that way. they won't be excluded.
I'm glad
they're
you're
still
explaining
entitled.
that.
They're still entitled to 50% share.
I'm glad you're saying that,
In
because
their
we've seen it in most of these shows where the in-laws come and fight and say, yeah, but you're not in the will. I
Yes,
know
but-
I was not in the will, but I'm entitled.
You're
Because
entitled.
by virtue, I own 50% of these things.
Exactly.
And sometimes some husbands become very tricky, or some, wives, and say, yeah, I'm leaving this one with nothing. I'm not going to write them on the will, forgetting that you and I have a different arrangement.
Yes, it's a different story. If you are married in community of property and then they write a will, you're still entitled to your 50% share. Naganjan.
And if you are in an antenuptial contract, then what happens if you're not in the will?
Remember, if you have an anti-nuptial contract, that means your marriage is now out of community of
Yes.
property. So that 50% share we're talking about, you're not entitled to it. It's only if
There's an accrual.
there's an accrual. If there's an accrual, then we are going to claim it. It has to be calculated somewhere, somehow.
I'd see 50%
Actually,
automatically.
actually 50% automatically. The calculation of accrual, we need to look at the anti-nuptial contract, the commencement values and other things. It has to be calculated. So explaining that, it might take the entire two hours.
I just wanted you to touch on that because I think that is where, and I've said this before, that the problem is that we need to educate our people because they make the wrong mistakes and we end up having to fight because, of course, if there are kids attached and they're my sister's kids, I'm not going to watch them, lose their home because now my brother-in-law is fighting with the kids who wants to marry someone else. That's how in-laws get string into, fighting for the assets and stuff because they're thinking you're going to marry someone else and these kids, this is their home. You can't just do that. And we then need to educate our siblings to say, no, when you enter into this type of marriage, you are the one giving this person the right.
Yes,
so at a later stage, don't expect us to come now, start fighting because you gave them the right.
Exactly.
You gave them. There's nothing that we can do at that point in time. But in that being said, now I want to get to the most controversial topic. This topic you can even see, I'm even starting to sweat because young kataza. I want us to speak about indaba yelobola.
Okay.
And can you please explain to us what are the requirements that makes ilobola a marriage according to RCMA? Because people fulfill all the requirements, the RCMA, and then later say, no, you're engaged. And I'm like, in my entire existence, but I'm like, you fulfilled everything that the Act speaks about in terms of you being customary married.
When we speak about ilobola or customary marriage per se, a number of people makes a lot of mistakes because they don't actually study or go to a legal practitioner to say, okay, I intend to marry in this type of marriage. They just go their own way. They don't look at the requirements in terms of the RCMA. The requirements there, they're not saying much about lobola being paid half, lobola being paid full, lobola being paid quarter. It says the parties must be between the ages of, they must be 18 years and above in order for them to be married in terms of customary. Number 2, the marriage must be negotiated or celebrated. This part.
But they're celebrated. They'll have more to celebrate.
The part about celebration, our African people make that mistake of thinking that by celebration they are referring to No. That meeting that you have with your when you meet as a family, and then you are sitting there and celebrating and this nowadays it's even they even take pictures.
Lobola celebration. They even have such a thing called Lobola celebration.
Exactly. So that is a celebration enough. So you'll hear a person saying that, no, the marriage was not celebrated, but they send you pictures of the celebration. They even have matching outfits in that particular instance. So you now ask them, what is this? And
it's
they're
like,
no, we were negotiating the marriage. These are negotiations. And then what are the classes and this and the other people that are there? You are celebrating that marriage. So linking the customary marriage back to administration of estates. Let's say, for an example, if you are saying that you paid lobola or you were lobolat, and then it happens that you die. What happens in that particular instance? And normally most of them they don't register their marriages. They don't. They leave it like that. Now I'm traditionally engaged.
Partially married.
I'm traditionally engaged,
Yeah,
but I'm
but it's not
partially
really
married.
serious.
I'm partially married. No, there's no such thing. And then in that particular instance, let's say you die or the spouse die. What normally happens, the death certificate, it will be out, and then there it will be written unmarried. And now that's where problems start, because you've been cooking for this man, you've been uhlala nabo futhi, and
Bakubiza
then
nangomakoti.
yes, and then now your death certificate it's in unmarried, and mighty unmarried kanjalo. Master of the High Court, they need marriage certificate in order for you to report the
The
estate.
estate, yeah.
So meaning now you have a situation of saying that now I need to make an
register.
application. Yeah, I need to make an application. You don't register automatically. You don't just allow your home affairs and go and register. No,
Izanai.
you don't register automatically like that. This is what you need to do. You have to make an application to the relevant court, the court that has jurisdiction to hear your matter.
Apply
You go
look
there. Yes, you go there and you make an application, right? And then when you apply there, you need to convince the court that, okay, Mina, I was married to this person. And in that application, remember, your in-laws are going to oppose. It's not an ex parte application where you just do the application and nobody opposes. No, your in-laws are going to oppose. They are going to file their opposing affidavits, and then in their opposition say, and they're going to testify there.
And I think Leo Oshoyo speaks to deceased estate. And just to bring it back to a case of Andabapila, because some people would say, how will they know if I don't let them know? Look at what is happening with Black Coffee and Ballet. Black Coffee say,
Exactly.
you have to prove.
You have to prove.
You have to prove that I married you
And prove it
traditionally.
Most of them, uthola ukuthi umfazi wakhona akasebenzi. She's unemployed and she doesn't even have the funds to go and pay a lawyer to do them. But that process, it's not mahala. It's not mahala. So you might find with your in-laws, no, bona banayo imali, and then they oppose. And then or maybe at some point you even decide I think it's years zonke lezi zinto lezi, and then your in-laws now report the estate. So it's not automatic ukuthi uvele usuke la uyo-register home affairs. No, you have to wait for that court order. The order, but the court has to give you an order to say, okay, now we are satisfied with your customary marriage, and then we are giving you that order. You can go to home affairs and then register your customary marriage. Then you go and register. That's where some people normally ask, okay, is it possible for a person to register a customary marriage? No, already.
Yeah.
Yes, it's possible, but that process iyenzeka with the permission of the court, obviously. So you have to approach the court and make that application. And then after getting that application, you go to Home Affairs and register them. Then after registration, that's when you can now come back and administer the estate. But if you don't do all of that, the in-laws will report the estate for you. And you...
I was confused. Umthetho sibancane sishadile mara sishadanga. Sishadile mara sishadanga mara mele apply ukushada mara yo kuningi.
So these things, when we tell people that this thing, when we talk about customary marriage, to be safe, mawufuthi ukuba safe in this whole particular thing, go register your customary marriage. And the Act also explains that part, that it is the duties of the parties, the spouses, the wife and husband, to register their customary. It's your duty. It's not my duty as a legal practitioner.
But you know, Bless Mashele, the most funniest, not funniest, I'd be insensitive to say funny. Trickiest thing for me is that men go and buy a lobol, right? Mara uksaina. You know, this lady was literally crying tears. She's like, my husband doesn't want to go and sign with me. I told him, I'm like, we're done. We are not signing yet. I'll tell you when I'm ready to sign. And I'm thinking, you already committed. So you want this marriage to be registered when you've passed on.
Exactly. And these are the same people when we tell them that, okay, if you entered into a customary marriage without doing any pre-nep, most people call it that, it's called an antenuptial contract, without doing that. So that means that marriage, it's in community of property. Go read the Act and stop arguing with us. Go read the Act. If you didn't conclude if you didn't conclude an antenuptial contract, your marriage
COP.
It's in committee of property. So another thing that we need to actually highlight, if you want to do an antenuptial contract, do it before you pay lobola. Do an antenuptial a prenup, and then go pay lobola. Don't pay lobola and go and
and do the prenup.
It has issues. It has issues. I think a number of people have seen it. It has issues. Although the RCMA does allow the parties to change their mind if maybe, for example, they concluded a customary marriage and then they later change their mind, like, no, but this one doesn't work for us. Both parties need to work together and change their marriage, make an application and change their marriage from the one in community to the one out of community of property. So they need to work together. Not ukuthi one person ahamba change ayiwa ayisebenzi kanjalo.
And abanye bathi angichange. And what do you actually do when that happens? Yes, since you brought it up.
Oh, yakachinja angeke umforce umuntu. No, even if you come to me as a legal practitioner, I'm going to explain those things to you that no, this process, both of you need to consent. And if the other one is not agreeing, asindaula. I mean, you can't do it alone. You can't. You can't just go at me and you change. I'm going to make an application to change my marriage. My husband is not agreeing at home. No, that's the very same husband you and
Bless.
You can't change alone.
Usho noma singano ex rape nje ngeke kwazi ukusiza ukuthi ngidonse lo muntu
No ways. So you both of you need to agree. When you want to change your matrimonial your matrimonial property system, both of you need to agree and go and see a legal practitioner. In that particular instance, that will be a notary public. You go and see a notary public, and then that application will be made and
ayikho nje even police station angikhapha ngimlanda
nix lekuthi uzomfoster uzomsayinisa amaphepha angazi asazi. But you both of you need to consent to this thing, and both of you cooperate, the both of you. So if you are saying, okay, me and my spouse, we want to change our marriage, you need to make that application jointly. Need to. Sure. The first applicant will be so and so. The second applicant will be so and so. The first applicant needs to be so and so, and the second applicant needs to be so and so.
Sure.
In one application, not one application, we won.
So then what happens when my partner lobolat someone else before and they broke up and then now I'm in the picture, and when I'm in the picture, my partner passes on, and then now suddenly the ex resurfaces and they claim to be the wife.
In a situation where, for example, he paid lobola to that one and then pays lobola to you again. That one normally that's what we call a polygamous marriage. The both of you will share everything equally.
So even without that one's concerns, because I read a case that said the new wife, they even went a step further to signing at Home Affairs, and they were in a civil marriage. But they'd broken up with that one. They did not divorce.
Oh, wait. In a situation where, let's say, for an example, the spouse or your husband had
lobolat
someone else, and then they broke up. They didn't do any divorce, and then now your spouse now went on and married you.
Yes.
In terms in civil. So that one who was lobolat can challenge your marriage. And your marriage can be declared null and void, because you don't just leave your customary marriage hanging like that. A customary marriage has to be dissolved by a decree of divorce. So leyo ukuthi hayi sahlukana sayishiya kanjalo iba nenkinga going forward.
A break up.
I see break up layer. I break up ayisebenzi futhi. Leyo ukuthi niya break up no, it doesn't work like that.
So if they've also married someone else,
yes, it's a bit complicated. But if they're married to somebody else, maybe they wouldn't come and challenge your marriage. I guess they're happy elsewhere. We're just thinking. So, my advice, good people, when you are married in terms of customary, if they paid lobola for you and whatnot, don't just leave your customary marriage hanging. Izokunika inkinga going forward.
Sure.
It causes problems. it causes problems because that person can just come at any time, especially masekshoniwe. Hey. Kuba inkinga because that person can just resurface and come and say, no, kindoda yaka ela.
The one who was partially married.
Yes. And
So
we
that's
also
why-
need to look at, when we do when we deal with these things, we normally ask, when did he lobola you? And he's like, no, 2002. And then when did you get married? 2010. So yayibona na ukuthi ihamba ngayiphi indlela.
Because I think that's where most confusion kicks in, to say this one sisainile, so this is one owandlula nasemsamo, because that's what they say. If awuthelwanga ngenyongo undlula ngemsamo, you are not
no.
married. That one did not even pass emsamo, but they can literally hold you at ransom and win this case because they met the requirements of RCMA and they never divorced.
That part becomes very. There are a number of cases where the traditional wife was declared to be the lawful wife. There are a number of cases, and a number of them uthola ukuthi ilabo mama laba ukuthi bahlala emakhaya and umuntu eze eGauteng and meet another person, then ashade naye basayine. That one is the one who's going to receive all these things because she's going to challenge this marriage of yours or pay certificate.
Mfazi wephepha, yasukela lapho, mfazi wephepha.
That one.
Sure.
They challenge it. Iyami estate. Kahle nje. Must be in estate and then kuza is like those kind of issues. We wait for those issues to be fixed, to be solved. It's not better after how long? But we wait. And then after that, that's when we can administer the estate. Let's say, for an example, in a situation where the husband paid lobola lapayana, wahamba yopatala lobola elsewhere. So when I hamba shia kanjalo, all those wives bathwantse batlhakane together and then administer this estate, and they're going to share everything equally. It's what we are referring to as a polygamous marriage. It's not a polygamous marriage because there are 3 wives. Then they share everything equally. Let's say, for an example, the total assets of the deceased thereof, they are 500,000. Then we take the 500,000 divided by 3. Kuyashare kanjalo. If kuneyingane nakhona, we take the number of kids, add. So the more ni business add abantwana, that's the more kuba kuningi. Kuba kuningi kakhulu.
So then I want to get to the issue that has gained so much traction now on social media, which is the issue of trust. Does everyone need to have a trust? Who would you advise to get a trust? Because I see now people are being advised to take a trust, and taking into consideration, of course, that there are different kind of trusts, that trust structures that are there, like testamentary trust and revos. So at what point must people take trust if they want to safeguard? And is it something that everyone must consider, even if you've got assets that are less than 500,000, 200,000?
With the issue-added trust, people need to understand that the trust, they are taxed differently. So the same way you saying when a trust, you must have the funds to administer that trust, because once the trust doesn't have or runs out from funds, iba nenkinga, because now those assets needs to be sold and. So what people need to understand, mawuba trust, if let's say you are married in community of property and you're saying okay, mina now I want to have a trust because angifuni ukuthi lo mama azobenefita from my things, lapho usadlala, because we are going to get those things, because if you are married in community of property, trust, they form part of the marriage. So unless if you guys you and your spouse you change your matrimonial property system, and then you now decide to say, okay, how do we protect ourselves from debtors, from creditors, and then you can have a trust layer, but umama has to know about it.
And they need to know how to manage it.
Yes, and you need to know how to manage it, because it must always have funds, and it's taxed different from an individual. So ha re deala ka dintho tsa trust when we are administering an estate, trust is taxed a bit higher than an individual estate. So one thing that people need to understand when we are dealing with trust, look at the implications that SARS has with trust, and look at also the administration costs. Can you afford those? Because IRBs, if you are appointing myself as a legal practitioner and you want me to be the administrator in that trust, obviously another thing that you need to take into account is that I have to be paid
Yeah.
for administering that trust. And if I'm administering that trust for like 10 years, how much are you losing? Or how much are you paying me?
So
Or
what
how
sort of
much
a
are you?
trust are
And
you
you can't
describing
appoint
now?
me only as the administrator. You need to appoint at least 2 or 3 administrators. So meaning that if it's me and you and the other one, so
You
you
need to
would
pay
agree
us.
with Spatala Oiwan. Spatala Bonk. And then the other administration costs are corner now. On a monthly basis, they are there. So people need to understand with e-trust, it's not just a thing you No, there need to be administrators who have to be paid.
But which trust in particular were you describing now?
It's normally if you are saying a living trust, the trust that you are appointing be a living trust. That one obviously the one that you're going to register your assets with, the one that you're going to put money for your kids, for your children, and whatnot, all the other things. Because as for the one that you say, okay, this one I wanted to start operating after I
passed
have
on.
after I have died or after I pass on. That one it's actually a bit of different because that can be administered by one or two people. So that particular type of a trust, it normally has to be incorporated in a will.
In a will, yes, testamentary
So
trust.
yes, it has to be in the will. So it has to be, as the testator, you need to outline how do you want it to operate and when should it open, in whose names, who should be the beneficiary. All those things, they need to be detailed by the testator. If the testator doesn't say anything about the expenses and whatnot, it becomes a problem because now we need to take everything and now sit down and structure it. And that is another expense because if I'm sitting and structuring the trust for you, obviously there are going to be expenses. But otherwise, it's a good way of administering the estate and taking care of your
loved
beneficiaries,
ones.
your loved one, especially minor children.
Yeah.
Because abo auntie at some point bayayidla imali ingane. When they receive the money, uvela ayithathe anayekelo wakhe umndeni at some point, especially makayithole i-lump sum like that, ayithathe hamba athenga umuzi kuphi kuphi, and then athule kanjalo, and then the kids are
They
suffering.
need to go to school. There's
So
no money.
for those ones who are saying, no, I have minor children and I would want my minor children to be covered, I don't care about the expenses for as long as they're catered for. Open a trust. And when you're opening a trust, it has to be a testamentary trust, meaning that when you go to a will, go to a legal practitioner or the person that, a financial advisor, but I would recommend that you go to a legal practitioner because you're going to sit down and talk about these things in practice. They'll explain to you how does it work and who can you nominate or who can you appoint. And you also have that part where you can appoint a guardian for your children, because if they are minor children like that, you know, okay, I can trust my children with so and so, or I can trust my children with so and so. But what you need to take into account is that appointment as a guardian shouldn't infringe anyone's rights.
Yeah.
Especially if maybe, for example, you are married. The spouse obviously has more rights than that guardian. So you wouldn't appoint somebody else as the guardian. Meanwhile, this other one, it's still there and. So obviously, if you appoint a guardian and say they might have an issue, so you'd rather inform them that, you know what, in the case I die, I think my children should be with so and so.
Yes.
So that the person doesn't become surprised at the later
Absolutely.
stage. and then they know and accept this thing and deal with it and yabo. So iba lula usually
Do it
when
like
they
that.
know. Yes.
Bless, thank you so much for sharing your pearls of wisdom today. I trust and believe that people will be able and you will be able and be empowered to make the right decisions around their deceased estate. Are there any last words that you would like to share with the people at home or the viewers from wherever they are that would possibly help them in navigating through this journey?
Well, my mandate normally it's bringing law or bringing this information closer to the people, bringing this information closer to the people because that's where we see a lot of issues. If our people are still struggling with the issues of classifying whether which marriage to choose, how to administer, then we still have and
A
a
lot
long
of
way
work
to
to
go.
do.
We still have a lot because if you look at this thing at the estates, it's not white people who are struggling there. And if you look at the whole marriage and customary thing, it's not white people that we see there. It's us.
True.
It's us, Kugitila and Mama Zala and whatnot. It's us with the same issues time and again. So when you want to get married, please make it a point that you and your partner, you and your boyfriend, you go and see a legal practitioner. They'll explain all those things for you.
True.
Or choose this one works for you. This one doesn't work for you. This one it's actually the one that works for people. This one is the one that pie.
Stay
So
away
you have
from.
stay away from this one. Stay away from
Yeah.
incompetent property. Go ref lapaya. Stay away from incompetent property.
You
Don't
heard
marry
it, you
incompetent
heard
property.
it, you heard it from the legal practitioner who deals with these cases all the time. I hope you'll find this information valuable. Thank you for joining us and thank you for watching. Please remember to like and subscribe. And until next time.